Hi guys, welcome back to Bar Talk with Ola. My name is Mojola Olua. Thank you so much for stopping by once again. Thank you for liking the videos, for subscribing to the channel, and for following so far. I've always said, I'm grateful for the feedback. It helps me, know what you want, and it helps build a community of legal interaction, which I'm really, really grateful for. So like I've always said, I'll say again that if you need to discuss something personal with me within the purview of all that's good and legal, please mail me at houseoflivingstones@gmail.com. For those asking for my contact, I cannot leave my contact here for obvious reasons, of course. So please mail me. I'll get to you faster than I would even get to a phone call or a WhatsApp conversation, as some have also requested, if you would just mail me. So today we want to talk about plea bargaining. Someone asked a question about plea bargaining, and that's why I've made this video. I hope it answers your question. I'll leave a link to it on your question as a reply to it, so that you can get the answer. I am encouraging you guys, if you ask a question on the channel, please go back to your question. I might have left a link to the answer on your question, or just look out for your answer in the subsequent videos on the channel. I try as much as possible to answer all questions. So today we'll be answering the subscriber who has asked for a video on plea bargaining. Plea bargaining usually applies to criminal matters, and in Nigeria, to my knowledge, it's only used in Lagos. It's enshrined or included in the ACGL. That's the Administration of Criminal Justice Law of Lagos State. I don't know if any other state has it yet. I doubt it. And I know that EFCC uses it. That's the Economic and Financial Crimes Commission. They use it as well because they prosecute criminal matters bordering around corruption, embezzlement of public funds, and what have you. So those are the only two applications that I know for plea bargaining in Nigeria at the moment. But if you're familiar with US criminal administration, if you watch foreign movies, you must have seen it. You see district attorneys offering plea deals to defendants, and defendant counsel arguing or negotiating plea deals for their clients with the district attorney's office. So you might watch A Fall from Grace by Tyler Perry. There's a mention of a plea deal for grace in that movie, but let's talk about the Nigerian application. So essentially, plea bargaining is used in criminal litigation or prosecution in order to allow the defendant to get a lesser sentence or plead to lesser charges in exchange for something. Let me explain it better. Plea bargaining is a negotiated agreement between the prosecution and the defendants, where the accused person, that's the defendant, pleads guilty to a lesser offense in exchange for a dismissal of other higher charges or offenses, or in exchange for a lesser sentence. So essentially, someone has committed murder, but they are agreeing to plead guilty to manslaughter, for a reduced sentence. You'll find it in sections 75 and 76 of the Administration of Criminal Justice Law of Lagos State, Nigeria. So you'll find the guiding principles and the rules in that law. I know that it was used in the case of the former IG of police in Nigeria, that's Tafa Balogun. So for instance, someone has embezzled millions of naira, so they ask him, plead guilty, you get a lesser sentence. Maybe instead of 10 years you get maybe 6 months, or you get a year, but you have to return the money. So that's essentially what it is about. There's restitution involved. There's probably an admission of a lesser offense involved. There's lesser sentences involved, and there's an admission of guilt for the particular offense also involved in exchange for a summarized trial and lesser sentencing. So that's what plea bargaining is. There are so many nuances and intricacies of plea bargaining, because the court is not involved. Okay, it's like your consent judgment in civil matters. In civil matters, parties can agree that, okay, let's agree on this, we present it to the court will adopt it as a consent judgment. So the same way, plea bargaining is adopted by the court and pronounced upon as the sentence in the matter, the decision of the court in the matter. But the court will not be involved in the process leading up to the agreement, because that would be wrong for the court. There could be charge bargaining, where you plead to a lesser charge for the dismissal of other charges, other weightier charges, and you could have a sentence bargaining where you probably agree to return maybe looted funds or make some restitution for in exchange for a lesser sentence. So those are the two types: charge bargaining and sentence bargaining. So the defendant's lawyer could approach the prosecution, or the prosecution could offer it, and the prosecution has to confer with the complainant in the matter if there are nominal complainants, and with the IPO in the matter as well. So to ensure that all fronts are covered. So if there's restitution that's to be done, the restitution will be done to the appropriate quarters, maybe monies returned to the coffers of the government, or restitution for the nominal complainants as the case may be. And I've told you that the court cannot be involved, and there must be no duress or compulsion by the prosecution on the defendant. The defendant must willingly agree to the plea deal before it is entered by the prosecution in court. And once it's entered, if the court is convinced and agrees with it, the court will make a pronouncement. If not, the court reserves the right to ask the parties to enter into trial, and so that a proper trial can be conducted in the matter. It is usually done in writing, and the defendant must have willingly and voluntarily signed. So in court, the court must confirm from the defendant that he has agreed to the plea deal before it makes a pronouncement on it, because it cannot be forced. If the court decides to impose a higher sentence than has been agreed, the defendant can withdraw from the entire arrangement. He can withdraw. So if the court is not convinced about the plea bargaining and asks parties to enter into trial, the court cannot make reference, or neither parties can make reference to the earlier agreement as an admission of guilt on the part of the defendant. No, it's not an admission of guilt. It cannot be referred to as such. It means that that agreement did not work out. The court asked them to enter trial, and now the prosecution must prove its case beyond reasonable doubts, as they would have done normally. So that's essentially what a plea bargain is. So you can look at section 75 and 76 of the ACJL for better understanding. Essentially, what a plea bargain does is that it saves the time of the court, it saves the time of all stakeholders in the matter. Then it helps the defendants on their own part to avoid a higher sentence. Then it helps to free up the court's docket, instead of going into full trial. So and it encourages, restitution as the case may be. So that's essentially what a plea bargain or plea bargaining is all about. Additionally, it helps to avoid, the publicity or the sensationalism that usually accompanies some types of trial. And of course, the state gets to not lose what they would have lost. When a party or a defendant agrees to return embezzled funds, the state gains instead of just, sentencing them to jail with no hopes of recovering the looted funds. So that's essentially what a plea bargain or a plea deal is about. That's all I have for you in this video. I will see you in my very next video. Toodles.